Hello everyone, welcome to the Labor Law Talk Show. I'm Tao Mrewa and we're going to talk about maternity leave today.
Tao, let's consider a scenario where an employee successfully passes an interview, receives a job offer, and subsequently informs the employer that she's due for maternity leave. Suddenly, the employer appears not to offer that employee a job. The employer withdraws his employment offer.
Kumalo, you can't do that. First of all, pregnancy is natural. You can't, as an employer, punish anyone for something as natural as pregnancy. So this is from a moral perspective. Now, from a legal perspective, Kumalo, listen to me. You can't discriminate against anyone because of their pregnancy. That's the starting point. Then the second point is maternity leave as a right is given to every female employee. And as an employer, you can't, in your interviews, ask questions that tend to want to expose the pregnancy status of the employee. Even at the stage of the interview, you can't also find yourself doing medical examinations that want to ascertain their pregnancy, status. In fact, when the Constitution was enacted in 2013, that was one of the issues that were protected for female employees.
Tao, what happens if the employer decides to withdraw the offer? What remedies are there for the female employee who is on maternity leave?
That's a problem, Kumalo. The moment you withdraw the offer letter, and it's clear that it's pregnancy induced, that's an unfair labor practice. The day you offered the contract of employment and the day the employee accepted the offer letter, an employment relationship was created. As the employer, you can only terminate that contract within the confines of the law. Now, the law cannot allow you to just withdraw an offer because there is no provision for withdrawing an offer letter in the Labor Act. More so, there's no provision in the Labor Act that allows you to terminate a contract of employment because of pregnancy. So, from the start, if you are the employer, Metul, you are on the wrong side of the law.
Thank you, Tao, for your responses. But Tao, let's discuss another scenario. What if an employee has already had a number of pregnancies and wishes to actually go further and proceed to other maternity leave?
I think I see where your question is going. Prior to 2023, there was this limitation where the law would say you are only allowed 3 pregnancies with a single employer, which would imply that the 4th one will not be covered under the maternity leave, which would mean the 5th one is also affected. After the Labour Amendment Act 11 of 2023 was passed, the law removed that limitation. A female employee can be on maternity leave as much as she wants.
Tao, maternity leave and entitlements. Does a female employee who is on maternity leave lose any of her entitlements?
The maternity leave does not terminate the contract of employment. At the very most, it doesn't suspend the contract of employment. The fact that the employee is on maternity leave means that she's still an employee. She's still entitled to the benefits that are contractual, that accrue in terms of the contract of employment. She's still entitled to her wages, to her salaries. Everything that accrues to any employee accrues to any female employee on maternity leave.
Thank you, Tao. For clarification's sake, what do you think are the potential negative consequences of this 2023 Labour Amendment? And what remedies would you suggest? This is in relation to maternity leave.
There could be silent discrimination of female employees based on the fact that employers may find it unattractive to employ female employees, fearing that they may at one point require, maternity leave. There are those concerns. My simple response has been that, gentlemen, ladies, we cannot be seen to be silently discriminating female employees. We cannot be seen to be punishing our female employees for something as natural as giving birth.